will not be subject to the claims of that beneficiary. So your children, if they get sued, they wouldn't necessarily be able to take their share of this trust. I will tell you that this is not a guarantee. If your beneficiary has the absolute right to take their property out, it may be that their creditor would be able to get after that as well. But we hope that this provision will give them some, at least modicum of protection. The next paragraph deals with the provision that sets kind of an ultimate end date for your trust. And that's what it's designed to do. We spend probably, 2-3 months in law school talking about this concept. It's called the rule against perpetuities. And basically, I'm going to try to sum it up for you in one sentence. When you're administering your trust, at the first to die of you and your spouse, you have to see which beneficiaries of your trust are still alive. 21 years after the death of the last beneficiary to die, the trust terminates and is to be distributed to whoever is entitled to receive it. Is that a fair summary of that law?
Very well stated.
So that's, again, like I said, to give an ultimate end date to your trust. We don't want it to go forever. Generation after generation after generation, this thing is sitting here. It kind of sets an ultimate date for it to terminate.
And practically speaking, it's going to end well in advance of that.
Right.
If you picture all of your children are gone and all of your grandchildren are gone, something's going to happen to the trust. It's going to be over anyway. So
that's right.
We satisfied Illinois law. That's
right.
Got it in there.
The next paragraph is really kind of a common sense thing. It basically says that any fiduciary or trustee that's going to be acting has to be legally competent in order to act. You don't want someone who isn't mentally competent or sound serving as trustee, even if you've named them. The next paragraph deals with accountings. And this is a special paragraph that we've inserted to give the trustee a little bit of comfort with respect to their liability. This paragraph basically says, upon written request, the trustee shall send a written accounting to the people who are entitled to receive it. So generally it's the income beneficiaries, and at the option, the trustee can send the accounting to future beneficiaries of the trust. Now, unless court proceedings are commenced on that accounting within 3 months after the time it's sent, the accounting will deem to be binding on and approved by all of those beneficiaries, and the trustee is going to be released from any liability with respect to matters that are covered in that accounting. So again, that's really just designed to give your trustee a little bit of security that if they send one of these written accountings out, they only have to wait 3 months to see whether they're going to be sued. And we want to give that trustee some comfort, and we also want to protect your beneficiaries by giving them a right to look at these accountings and see whether or not they believe the trustee is doing a proper job. The next paragraph, again, kind of gives the trustee a little comfort. It basically says that before the trustee makes any distributions of the principal of the trust, they have a right to require the settlement of any open accounts. So if there's any open issues out there that haven't been resolved yet, the trustee has the right to say, I'll make the distribution that you're requesting. However, I want these matters solved first so that I know that after I make the distribution, I'm not going to be later sued and I'm not going to have the money available. I want to skip ahead a little bit and talk about the last paragraph in here, and this is an important issue that you're going to need to tell us how you feel on the matter, and it's with respect to adoption. Now you have an option here, and if you've already told us your option, it will be filled in here. If you haven't yet, it's time to make a decision on this matter. You can choose to have your property distributed into your bloodline. So if, for example, you said in your family trust that you want it to be distributed equally to your children and their descendants, we have to kind of define what a descendant is. You can say that a descendant includes only the bloodline. So only people who were born from me or from my children are included as a descendant. In the alternative, you can say that this includes adopted children or grandchildren. So, if your grandchildren or great-grandchildren happen to adopt somebody, you're saying that their share, they would be included as if they were a bloodline of yours or in your bloodline. So you need to tell us which option you would like to choose, and we can correctly state your position there. The next article deals with, and is titled, Special Needs Trusts. Now this is kind of a long paragraph, but I want to give you just a basic summary of what it's intended to do. If it turns out that one of the beneficiaries of your trust has a disability, that may be a mental disability or a physical disability, and oftentimes it's something that comes up later. It's not an issue when you write the trust, but maybe one of your descendants ends up being disabled for one reason or another, or there's a car accident which leads to a disability. We have this provision in here to cover that situation. And it basically says that any money or property that would be distributed to that person who's disabled, that's to be held by the trustee. And the trustee is authorized to pay for the extra or supplemental needs and comforts of that disabled beneficiary. Now that money will not be paid directly to the beneficiary, but will be paid for the benefit of that person. The goal here is so that if the property is owned by that disabled beneficiary, they may be disqualified from receiving benefits from the state or federal or local government. For a common example is Medicaid. You may be, since that's an income and asset-based program, your beneficiary may be disqualified from receiving benefits if they get this distribution from your trust. So what we're saying is, trustee, in that situation, hold that as a separate trust and do not pay any money out if it would disqualify that beneficiary for those state or federal programs. Instead, pay for the things that the programs don't provide for. So if there's extra comfort and care items that the state or federal government is not paying, trustee can then pay for the benefit of that, buy those items, for example. So that's what this provision is geared to do. Keep in mind, at the end of this provision, we've included a clause that says how this trust is to be distributed when this beneficiary dies. Again, we're looking for some input from you as to what you would like to see happen to this trust when that disabled beneficiary would pass away. For now, though, we've included a provision that says that it goes in accordance with whatever you said with respect to your family trust. So however you want your family trust to be distributed, we're saying this property goes the same way. So if you want something different, just let us know.
Now, what more happens if one of these government programs challenges this trust?
Well, if a government, and that may happen, that a government entity, for example Medicaid, may challenge the trust, may say that no, we're going to deem that to be included in this beneficiary's estate and we're going to disqualify them. You would need to let us know as soon as possible so that we can deal with that situation. The state statute, the state law in Illinois allows for you to create this kind of trust, and it specifically says that these assets are not to be included into that disabled beneficiary's estate. They're not to be counted against them, and the trustee has the right not to pay those out. But if the trust is ultimately challenged, then the direction is given to the trustee to distribute it out to the other beneficiaries of the trust in accordance with what you've said here, and not to the disabled beneficiary. So it's designed to terminate and be distributed away from that disabled beneficiary.
Then the next section that I'm going to be talking about is entitled Trustee Powers and Duties. And this particular section, which, Melissa, correct me if I'm wrong, but this is the longest section in the trust, goes on for several pages. And I want to sum up those pages. I'm looking here. In the draft that I'm looking at, it goes from page 10 to the top of page 18. Now keep in mind, there may be special drafting in this more, that your pages may be different. But my point is, there's a lot of different sections, and I'm not going to bore you with reading through each section. What you're trusting us to have done is to give the power to your successor trustee, that is the person, bank, or trust company you've named to fill in for you when you're not able to serve as your own trustee, that you're trusting us to give them the powers that they need in order to carry out the terms and provisions of your trust. Now, many times clients have specific special powers that they ask us to put in. They may have a corporation, they may have an LLC, they may have farm property, they may want to give options, they may want to give rights to buy. Those sorts of powers, Melissa will have highlighted for you in the power section so that you can look at those and make sure that they are stating what you want. But other than that, it's basically you're trusting us to give the trustee the power to do what you've asked them to do in the event you are disabled or you have died. So having said that, I would direct your attention to the powers. They're not really important to you because you are your own trustee. You can do anything you want. Anything you can do as an individual, you can do as trustee. You can end the trust, you can invest, buy, sell, trade, swap, do anything that you want. So the powers really aren't that necessary or needed by you. because you can do anything you want, but they're needed by that successor trustee. And as I said, that ends at the top of page 18 in my copy, and we go into some, I guess, additional administrative clauses, really, Maury, that
Sure.
you're going to cover.
One provision I would like to point out, and I think this is a concern for a lot of our clients, is there is a provision in the trust powers for the surviving spouse to live in your residence without forcing the trustee to sell that residence. So that is in there for your spouse's protection. I just wanted you to be aware of that power. The next article is entitled Collection and Transfer by Successor Trustee. Now, upon your death, the next in line trustee will be required to kind of marshal your assets and possibly re-register them into the new trustee's name so that they can hold them in the trust and distribute them in accordance with the terms of the trust. So this next article here is designed to give them that power. It basically is a power that they have the right to collect and transfer or re-register all the assets of the trust into their name as trustee. The next article talks about trustee employment provisions, and it is entitled Trustee Employment Provisions. Article A gives the trustee, the next in line trustee, that is, the right to resign by giving 60 days written notice to a majority of the income beneficiaries. So you don't want to force your trustee, if they don't want to do this job after you pass away, to do it. So this gives them the right to resign.
More than where it says to the persons described in paragraph, my draft is paragraph 11D. That's really, they don't have to flip back to that, it's the income beneficiaries?
Yeah, that is stated here as well, but if you go down to paragraph 11D, it says that decision, or the notice, is to be given to a majority of the beneficiaries who are then entitled to the income of the trust. So that's who this notice would be given to.
So at the death of one spouse, the income beneficiary is the surviving spouse, so it's just the surviving spouse has that control.
Right, the surviving spouse would have that control, unless, of course, as Roy mentioned before, someone disclaimed. But in the normal situation, yes, the surviving spouse would be the income beneficiary, so that's who that notice would go to.
Okay.
The next paragraph says that, and this is an optional paragraph, again, you need to tell us how you want to handle this, but the next paragraph, if it's in your document, deals with removal or firing of the trustee. If you've already told us that you do not want to have your income beneficiaries to have the right to fire your trustee, that provision will not be in here. If, however, you would like to have the beneficiaries have the right to fire your trustee, the next provision deals with that, and it basically says that majority of the income beneficiaries have the right, with or without cause, to fire your trustee, in which case whoever you selected as the next in line will step up and serve. I want to point your attention to one provision in here in this paragraph that's important. We've said that in no event can your spouse serve as trustee. And as Roy was mentioning in the early stages of the trust when we were talking about the marital and family trust, this is geared towards those IRS tax rules. We don't want the IRS to treat your trust as if it's all owned by your spouse. So that's why we put in this provision to say that your spouse is not to be selected as any successor trustee. So just confirm that we have the spelling there correct.
And that's a strategy that we recommend. It's not an IRS requirement.
It's not required by the IRS, but yeah, it is a strategy. We want to avoid any option for the IRS to argue that this should all be treated as if it's owned by your surviving spouse. The next paragraph is an important one because it deals with the selection of the successor trustee. So the person who's going to manage your trust after you either pass away, become incompetent, or decide you just don't want to do it anymore. So please verify that we have the name or names of your next in line trustees spelled correctly and their addresses are correct. Now we also end the trust by saying, or end this provision by saying, if the people you've selected can't serve, don't want to serve, or have passed away, or for whatever reason they're not going to serve as the backup trustee of your trust, then we say then any one or more of your descendants or any corporation is going to serve. And if it's going to be an individual, of course they have to be of the minimum age that you're requiring for distributions to go to. So that age will be filled in there as well. And again, the notice that if you're going to resign as trustee, the firing of the trustee and the appointment of a successor trustee beyond the people that you've named are going to be made by a majority of the income beneficiaries, and that's what the next paragraph says. So the income beneficiaries have a lot of authority when it comes to those types of things. think that's it for that paragraph.
Then the next paragraph that I'll be talking about is life insurance provisions. Many clients, not all, but certainly many, and probably the vast majority of you have life insurance. And it is extremely important to have life insurance be part of the trust, particularly if you're using it for tax planning purposes. You will hear us recommend that you change the ownership and beneficiary, but certainly the beneficiary. If you don't change the ownership, your trust should be receiving the funds. So in my situation, using myself as an example, if I have life insurance and I have a trust, I want those death benefits to come into my trust and possibly have my trust own the policy. The reason I would like my trust to own the policy is if I become incompetent, my trustee, in my previous example, Maury is my trustee, he can deal with certain options and provisions and so on that I may have in that policy simply by the fact that he's my trustee. I don't have to have myself taken into court and proved incompetent. You can do that for me. So this life insurance provision is recognizing the fact that it is important to have your life insurance be part of your trust. And it's giving your trustee special rights with regard to those policies. But it does say the trustee is not obligated to pay the premium out of the trustee's own funds. So you don't get off the hook on paying the premiums. The premiums still have to come out of the trust. But other than that, you're saying trustee, go out and collect it. The reason we put a separate provision in for life insurance and not necessarily for real estate or bank accounts or other investments you may have is life insurance companies like to think they're special, and they like to see clauses in here that allow the trustees to specifically deal with them. So that's the reason we have that. And oftentimes, life insurance is one of the more important assets the clients have. Finally, we get to a section called amendments and revocation. And that should tell you that this part of the video is getting to an end. And you're all breathing a sigh of relief, I know. But amendments and revocation, let's think of what we covered. We've created a document called a trust, a declaration of trust, that will provide for you as our clients what you want to do during your lifetime. It can cover you when you're extremely ill, you're unable to manage your own affairs, you don't have to worry about guardianships or being taken to court and proved incompetent. The trustee can literally do everything that may be needed for your care and your comfort. That can be done. So it takes you through when you're healthy to when you're not so healthy and to death. Death occurs is saying take care of my expenses, whatever they may be, just so long as they're valid expenses. My expenses are done. If I have a surviving spouse, remember the marital trust we talked about and the family trust we talked about, those are going to be considered. You're always going to have the family trust. You may or may not have the marital trust. It's only for the amount over the federal exemption. That family trust and that marital trust is held during the lifetime of your surviving spouse. At the surviving spouse's death, then it's set up to deal with your children and or grandchildren or other beneficiaries. So there's a lot going on in this trust document, and it's important for you to realize that life does go on after you sign this, and life has a way of throwing us curves. You may want to come back and say, Maury, that trust you did for me back 15 years ago, things are not the same, I need to amend. Can you get it up to speed and tweak it a little bit to reflect what's really going on now? I now have grandchildren, I want to create an educational fund for them. All of that can be done. Or if you get to the point where the federal government says we're not going to have death taxes anymore, we're going to repeal it, you may come in and want to revamp the whole thing. You may want to revoke it. You can do that too. You can take assets out, you can put assets in, you're totally in control. This is not an irrevocable situation. You can change it as life continues. Then we have the closing paragraph. You'll see where you're going to sign as the declarant, the person setting up the trust, as well as the initial trustee. Please again check the spelling of your name and then your name and signature will be notarized as you see at the end of the document. So that concludes the trust. We'll be going on to the will.
The next document we want to talk about should be included in your packet of documents that you received from our office. It's called, labeled at the top in bold letters, Last Will and Testament of, and then your name should appear. Please make sure that we have spelled your name correctly, including a middle initial if you wanted one included. The opening paragraph of this document states that you, and again, verify that we have your name spelled correctly, and your address should appear there as well. Make sure we have that correct. That you're making this your will and you're revoking all your prior wills, and there's a word there called codicils. A codicil is just an amendment to your will. So you're saying that the will in front of you is going to be your will. If you've done a will in the past, or if you've changed a will in the past, all of that is over, and this is the only document we should be looking at your death. The first paragraph is called interment, and it's labeled and underlined there. And the word's a little misleading. This paragraph is designed to cover how your funeral and burial, where you want to be buried, and some of you may have chosen to be cremated. And if you have chosen that, then that should appear here. So we should have said whether you want to be buried, and if so, where that's going to be, whether you want to have memorial services, and if you wanted to be cremated, it should state there that you do want to be cremated and what should be done with your ashes, and that the expenses associated with your funeral and burial or cremation will be paid from your estate.
And then moving on to the next clause, typically what we are talking about and what we're dealing with is personal property. So I would ask that you view that article as I give you some of my ideas and then some specifics. The personal property article is the place that you would put in writing any personal item that you want to go to a particular party, person, place, charity, church, something that you want specifically. I want the necklace I received from my grandmother to go to my great-granddaughter. I want my hunting items to go to, I want $5,000 to go to each of my grandchildren. Those sorts of clauses find their place in the personal property article of the will or in specific language in your trust. Either way, as Maury indicated during the video when we were talking about the trust, either way it's going to happen because we have saving language in the trust that says if something has been said in my will, like I want $5,000 to go to each of my grandchildren, even though all money is held in my trust, trustee, I want you to follow the directions I gave you in my will, or I gave in my will. So you don't have to worry, well, Roy is saying it should be in my will. I'm saying it can be in your will or in your trust, but if we've chosen to put them in your will, you should be seeing them in the personal property clause. There is always in the personal property clause a general clause that says the remaining items of my personal property are to go this way. Or if you haven't had any specific bequest, certain things going to certain people, then it'll start off with a general request. And it will say the personal property listed below in this article, you're saying in this article, I give all of my personal property, including but not by way of limitation, jewelry, pictures, books, household furniture and appliances, clothing, automobiles, articles of household or personal use, or ornament of all kinds. So that clause is meant to give you the impression that it's all inclusive. Is picking up everything in the way of personal property, and typically you go to your surviving spouse. If your surviving spouse predeceases you, then you will have a gift over. It's going to go to other people, typically children or grandchildren, churches, charities. Usually don't come into play on household goods, appliances, and those sorts of things. They're usually very personal, and it stays with family members. It does not include, and this is the final paragraph of that section, it does not include certain things. And it will say the following types of property: money,